avoid guardianship or conservatorship if we're alive but incapacitated?
So that's a really good question. So we've been talking about long-term care. I talked about that in the previous video and how we can avoid those costs. But while we are still alive, oftentimes our kids actually have to go through guardianship or conservatorship hearings to be able to make decisions for us or to pay our bills or whatever. And we do not want them to have to do that. I often joke that living probate is actually worse than after death probate. And that's what guardianship and conservatorship are. It's basically living probate. So, say that I get dementia and I'm no longer able to make decisions for myself. So, my kids want to lock down my bank accounts. They want to make sure that I'm not giving out checks to all these scammers that come calling, because there are a lot of scammers that always come calling for elderly people. And this has been going on forever. So we want to make sure that our kids, or for us, for our parents, that we do have the ability to step in and lock things down if we need to. In order to do that, our parents have to either have power of attorney documents that are legal and perfectly set up, or they are going to have to get, or we're going to have to go through guardianship or conservatorship proceedings. So I think when we hear the term guardianship and conservatorship, I think a lot of people can go back a few years and immediately think of Britney Spears. Same thing. That's what it was. Britney Spears, you can argue either way on this, but the argument is that Britney Spears had some mental health issues. I don't know if drugs were involved ever, if that was ever a thing. But so basically her dad had guardianship and conservatorship over her and was making all of her decisions for her because she was not competent to make those decisions for herself. This is a severe case. Obviously, this is a younger adult. I think same thing with Amanda Bynes, right? So these are younger adults that have been wrecked by Hollywood. But normally, for most normal people, this would happen more when we get older and we get dementia or we have cancer and it starts to affect our ability to make decisions or something like that. So guardianship or conservatorship is basically where, if I'm doing this for my parent has dementia, I am having to go through a process called living probate in order to get the authorization to make financial decisions for my mom and then make healthcare decisions for my mom. Conservatorship is financial, guardianship is healthcare. This can all be avoided if my mom has the correct power of attorney documents. So in Georgia, she would have a Georgia Durable Power of Attorney, which is financial, and then she would have a Georgia Advanced Health Care Directive. So the power of attorney is going to say, okay, I have the authority to handle all of the normal powers: bank accounts, taxes, property, brokerage accounts, all of the normal abilities. I would be able to manage that money for her and access that money to pay her bills and keep her life running. Then there's specific grants of authority in this document, and these are going to be a lot more overarching. So it's very case specific as to whether our clients initial these or not. But do you want your agent to be able to fund a trust for you, to create a trust for you? Do you want them to be able to update beneficiary designations? And again, this is really case specific, because if your kids hate each other, you probably don't want to give one of your kids the authority to knock your other kid completely out of your estate plan. Just saying, probably not a great idea. So very important that, and very case specific as to what we initial, but it's a very important document. Now, this document, it's important, but what we've realized and what we hear a lot is that financial institutions don't really like working with power of attorney documents because there's a lot of liability for them. And so a lot of the times they either run it through compliance. This may take 3 to 6 months. And then the legal department might still just completely erroneously just throw it out. We never know. They're weird. The Edward Jones, the Charles Schwab, all of these, the Truist, the Bank of America. Power of attorney documents are important. They're not the end all be all. This is also where a revocable living trust can come in handy as well. If you have a revocable living trust that actually owns your bank accounts and your brokerage accounts, then your incapacity trustee automatically has the authority to step in and access these accounts. So this is even a better way to avoid that conservatorship proceeding, which costs a lot of money and takes a long time, and you have to continuously report back to a judge. So power of attorney documents, important. Revocable living trust takes it one step further and provides even an extra layer of protection. On the other end, we have guardianship and healthcare decisions. So as we get older, if my mom had dementia, there's a lot of healthcare decisions that are going to come into play with this. Honestly, as dementia progresses, people often get infections more and more often. And at some point, there might actually be a discussion as to whether or not you keep treating those infections. Because in Georgia, we don't have assisted suicide. We don't have a magical pill that someone can choose to take to put themselves out of whatever misery. But there are other ways that if we talk to our family and our family members and you plan for this in advance, that can actually speed up your passing away at these very end stages of dementia or severe terminal illnesses. I'm not a doctor either. I'm just an estate planning attorney, but I did represent 8,000 doctors, so I did hear a lot about this. But you want to make sure that you have someone that you trust and that will respect your wishes as your healthcare power of attorney. This is so important. You do not want to name your overly emotional child as your healthcare agent because at the end of the day, they are not going to be able to make life or death decisions for mom or dad. So you need to name someone that's pretty rational, pretty level-headed, and that will respect your decisions and know when it's time to let you go as quickly and painlessly as possible. There's a lot of things that go into this. If you do not have that document, guess what's going to happen? Your kids who all have different personalities and different thoughts about healthcare and about mama's healthcare, they're going to be fighting it out in court and it's going to drag out. Meanwhile, who's making decisions for you? Some random doctor. So it is really important that you have these discussions with your family and that you have all these documents in place so that someone has the legal authority to make financial and medical decisions with you for you without having to go through guardianship or conservatorship / otherwise known as living probate proceedings. Because again, very expensive, not fun, very ripe for conflict in your family. So we definitely want to avoid that.